welcome to the Protect or Punish Children, Counter-Terrorism and the Criminal Justice System webinar. And welcome everyone, and to our panel I'll introduce in a moment for joining us. This webinar is brought to you by the Garden Court Chambers crime team, the Children's Rights team and Child Rights International Network, otherwise known as CRIN. This event will be recorded so that we can share it more widely. This webinar is part of Garden Court Children's Rights Team seminar series celebrating World Children's Day on the 20th of November 2025, which, as many of you will know, is the anniversary of the signing of the UN Convention on the Rights of a Child. To protect or punish children, counter-terrorism and the criminal justice system is the title of the latest report from the Child Rights International Network. And it illuminates the creeping advance of the UK's counter-terrorism system and how it's come to threaten children's rights from pre-criminal to pre-trial to trial and sentencing. The report argues that there's a pressing need for reform and adoption of approaches that genuinely protect children and are founded on the principles of child justice. So this webinar will explore the themes in the report and discuss how the current system can be improved for children. So I am Mark Gatley, King's Counsel. I am the head of the crime team at Garden Court, and I specialise in defending the most serious criminal cases, frequently involving child defendants accused of the gravest of crimes. Kate Aubrey-Johnson is a colleague of mine at Garden Court Chambers. She's a youth justice specialist barrister and mediator with a background in criminal defence and public law. She co-authored Youth Justice Law and Practice, LAG 2019. She's chair of the Ministry of Justice's Working Group on Youth Advocacy, and also advises across the youth justice sector and works with the Law Society, criminal bar associations and Inns of Court College of Advocacy to develop specialist child representation skills. Dr. Miranda Bevan is a lecturer in law at the Dixon Poon School of Law, King's College London, and she specialises in criminal law and criminal justice. Her research has focused on children's experiences of police detention, and she's worked to develop national training resources on children in custody, including for appropriate adults. And she also volunteers as an appropriate adult in Southwark. Jonathan Hall, King's Counsel, was appointed independent reviewer of terrorism legislation in May 2019, producing 5 annual reports and reviews of domestic and international counter-terrorism sanctions for the Treasury and the Foreign Office. In February 2024, he became the first independent reviewer of state threats legislation under the National Security Act 2023. On his recommendation, legislation is currently in train for the creation of youth diversion orders, and we'll hear, I'm sure, more about those. James Megan has a practice in international criminal law at Garden Court. Prior to coming to the bar, he worked for several human rights organisations and has provided advice to numerous NGOs. He's a former member of the Policy Council Liberty and the legal advisory panel at the Child's Rights Network International. He's currently a lecturer in criminology at the Open University. Alexander Roxburgh is a legal policy and advocacy advisor at CRIN and leads CRIN's work on counter-terrorism, examining how laws, policies and practices affect children's rights, and also works on children and armed conflict, especially the interaction between conflict, climate change, and environmental degradation and their effects on children. So those are the attendees, the panel rather. So thank you very much for joining us. And now I think if you could kick off, Alistair, with your presentation of the report.
I'm actually going to pass that over to James to lead on that bit for us. Thanks very much, everyone. It was a great privilege to write this report with Alistair over the over the summer, and I'm delighted to be presenting it here. I suppose one thing to mention briefly is that we were privileged to have Professor Conor Gearty give us a foreword for the report just before his untimely death, and I think it's worth having a very brief moment to just think about the contribution Conor's made to human rights generally and the knock-on effect that's had for children's rights as well. Connor was a real inspiration to anyone in the field, and anyone who had the privilege of meeting him, I think, is talking about what a terrible loss his sudden and surprising death was. Still very recently and very raw for many people. The first thing to say about the report is I think anybody who's done any sort of youth justice work in England and Wales will feel a lot of the themes that are coming out of it are common across the youth justice space as well as those that apply to terrorism. So in some sense, some practitioners may say, well, this is quite familiar to me. This is very straightforward. But there were also some major overarching themes that we wanted to talk about. And so the reason that this has sort of become a bigger problem than it might have been 7 or 8 years ago is the proliferation of young people engaging with terrorist ideas online. And that allows for children who are potentially quite vulnerable in other aspects of their lives, whether that's neurodivergence, whether that's just plain loneliness, whether that's poor parenting, any of the normal vulnerabilities that affect children can lead them to spend time alone online and to drift possibly through the influence of algorithms and social media and so forth into engaging with ideas online that touch on some of the preparatory crimes that we now have, and therefore things that couldn't quite be a crime, say 20 years ago, are now criminal and possible to commit online on your own as a young person. And so we have a lot more young people dragged into what was traditionally a sort of an exceptionalist space, the terrorism space, and that is a problem. And one of the things that we noticed, and you'll see coming out very clearly from the report, is how difficult it is to analyze this if you are outside the secretive world of terrorism control and counterterrorism controlled by the state, because data is very hard to come by. What data there is inconsistent. It's not always used consistently across state agencies, and it's not used in the same way. And so this makes it very difficult for anyone on the outside to understand the scale of the problem, and that is a difficulty for us to analyze it. And that's a problem for the state for two reasons. The first is these are the counterterrorism movement. We've become very comfortable with it now since the global war on terror is entering its 25th or 24th year. But these are very major implications or changes and interventions in human rights across the country. And I would suggest that it is on the intervener to justify that and to demonstrate to us that it is effective and that it is making us safer, these major sacrifices we're making in our civil liberties. And without data, the state cannot point to an, any sense of effectiveness or any sense of added value that these interventions in our lives provide. So it's a legitimacy problem for the state in legitimating its counterterrorism agenda, and it's also a trust problem for us as citizens if we can't know how many children are going to be arrested, how they are processed, and to know this in a consistent way. So one of the first recommendations we make is that there be better statistics created by the state in order to assist civil society, academia, and practitioners in understanding the scale of the problem of children associated by or affected by the counterterrorism movement. The report itself is broken into four sections. We start with the pre-criminal section, and that includes this movement since the start of the war on terror to make criminal those spaces that were previously not criminal in themselves, but were people thinking in the direction of a crime or thinking about committing a crime and so forth. And that space, as Conor Gearty says in the forward, is a space that used to be known as freedom and is now been criminalized. And I think that it's not terribly difficult to find stories across both the adult and youth justice counter-terrorism experience, where this broader expansion of what is criminal is turning out to have some pretty unjust results. And then within the pre-criminal space, we also talk about the stop and search, the use of stop and search on children in particular. And this is an area where there's some statistics, but again, difficult to kind of find consistency across the years and across the agencies. One conclusion, though, from the stop and search point is that while a significant number of children are arrested under the stop and search powers, very few are going on to be arrested, or sorry, a significant number of are stopped, but much fewer are going on to be arrested, and even fewer again, as very small percentage, lead to conviction. And what that demonstrates is that perhaps the stop and search process is being used as a process of intimidation and control rather than as an administrative process leading to proper conviction and punishment under the supervision of the courts. We also talk quite significantly about diversion, in particular the Prevent program, and a huge amount of material has been spoken about Prevent with relatively recent reports. CRIN has been contributing to the debate on Prevent for many years and has its own report on children affected by Prevent. And everyone here will be familiar with the criticisms of Prevent. And we would say, and it's very simple, the continuous theme throughout this paper is that all of these interventions need to be child rights compliant and need to be run in the best interests of the child. And what we're seeing is much more of a trend towards the criminal justice system being used in a punitive manner in a way to punish people rather than to look after children. We then move on to the pre-trial section of the report, and that talks a lot about how pre-trial detention is managed. Look, when you talk about terrorism, we think, oh, these are people involved in potentially atrocity crimes, but the truth is, of course, that many of these people are in fact involved in internet chat, and we would suggest that very few of them would therefore need to be detained before trial. And similarly, when it comes to the trial itself, we would suggest that very few young people who are facing internet offending should be tried in the Crown Court, and almost all of the terrorist offending that a child can face with, except for the most serious offending, would be crime that can be dealt with in the youth court. And we would also like to see some more imaginative use of moving of judges to the youth court if, for example, someone is to be sentenced by a crown court judge or circuit judge, excuse me, then perhaps the circuit judge could move to the youth court and try to create a more youth friendly, youth justice compliant or child rights compliant, excuse me, case in the youth court. And so we've tried to think through ways in which principles of child rights can apply there. And the final section then is the sentencing section. And it's been a long-standing position of CRINs and of anyone involved in child rights, really, that life sentences should never be used for children. And this is a peculiarly Anglophone phenomenon, the life sentence for children. When Britain left the European Union, the day before they left, there was 444 or so children facing or serving life sentences, or people serving sentences of life for crimes committed while under the age of 18. After Britain left, there was 4 people in the European Union serving that. So it just shows completely how out of step with our neighbours we are in the UK in terms of how we punish children. And that's a continuous theme throughout the report, is this focus on punitiveness. And it's worth remembering, as a criminologist, it's worth reminding people that there's very little evidence that punishing people achieves any of the aims of the criminal justice system, whether that's for adults or children. Punishing people does not demonstratively reduce recidivism. It does not demonstratively increase public safety, and there's very little evidence to demonstrate those things. So what it does do is it allows society to make statements about what it considers to be serious, and it inflicts pain on individuals. But if the pain is being inflicted for limited practical ends, it is suggested that that may not be worth the infringement on human rights that goes with it. There are 15 recommendations. We don't have time to go through them all here, but I think it's instructive to think of them in terms of some of them are writ large in the sense that we want to see an improvement in that data collection and a general move towards treating the rights of the child as paramount rather than punishing people as the central aim of the process. And then we've also provided a series of individual suggestions on each of the four sub areas that we've set out. And I hope anyone who's had a chance to look at the report, even briefly, has found it to be at least somewhat stimulating in helping them think through this relatively unstudied aspect of counterterrorism. There's a lot of work done on terrorism, on counterterrorism, but there's not actually that much work done on children in this space. And so hopefully this will kickstart a little bit more debate and a little bit more research, as well as ideally some policy changes. Thanks very much, Mark. I'll hand it back to you.
Sorry, sorry about that. All right, thank you very much. So, Alex.
Great, thanks, Mark. So, one of the things James mentioned there in a very timely way is that more young people are being dragged into terrorism space more and more. And actually, last week, the government published its latest set of data in relation to the PREVENT strategy that I know many of you joining this call will be familiar with. Last year, there was a significant increase in the number of referrals, particularly post the attack in Southport, with 8,778 people being referred. That's the highest it's been in a decade. Of these, more than half were children, so 4,700 children were referred to PREVENT. Yet just over 11% were adopted into channel, so a relatively small proportion were adopted in. James, I'm just going to go back to you, maybe, if that's okay to start off with. Do you think, from looking at this report, looking at PREVENT within the report as well, in 2025, is PREVENT the best way of preventing children from being drawn into terrorism?
It's very hard to see how that could be the case, Alistair. It's a system, and one of the recommendations we make in the report is that prevent or any diversion reform, any form of diversion that follows it, not be run by the Home Office, because ultimately the Home Office is an agency that is used to the sort of punitive form of criminal justice and a heavy-handed policing form of criminal justice. And its approach to terrorism down through the years has been consistent with that very forceful approach. And it's clear to us, having conducted the research in the report, that PREVENT is part of that school of thought rather than something that serves to operate in the best interest of the child. And so PREVENT in its current form seems to me, and I think to anybody who's experienced with it, to be an insufficient way to deal with these often vulnerable people and how they get drawn into this terrorist behavior.
And PREVENT's obviously not the only mechanism that's out there. One of the other mechanisms that James mentioned was stop and search. That's long been controversial, but the specific powers that there is for stop and search under the Terrorism Act are of particular note for this conversation. Miranda, I was wondering if you could speak a little bit to this. Should the police still have stop and search powers under the Terrorism Act?
Well, as you mentioned, stop and search powers generally have a really long and problematic history, and marginalised children and young people tend to bear the brunt of the exercise of those powers. I mean, the power that we're thinking about here is, one might say, extremely widely drawn if we take into account the guidance that's issued for officers exercising the power under the Terrorism Act. And the low find rate is striking, even in comparison to the low find rates generally in relation to stop and search power usage. So there's always a challenge when we talk about removing a power that sort of counterintuitively, actually, it can leave children open to kind of vulnerable to exploitation by others. But in this situation, there are plenty of other powers accessible to officers who may have suspicions about a child in public. And so there's no concern there. There aren't many searches, as you will know from the data, but any search which is experienced as unjust by a child can have a really lasting effect on their appreciation of the legitimacy of the police, and can alienate children and their families often from the authorities. And so in that sense, even the few that occur are problematic. And so there's good evidence here to suggest that in the absence of evidence that officers are using this power effectively, that it's something that should be considered for withdrawal.
Thanks, Miranda. One of the things I think we found when we were exploring this report all the way through was a bit of a gap, we would say, in opportunities for diversion for children who are vulnerable, particularly in a space where there can be a diversion option which isn't dependent on an admission of guilt. It's something that the government's looking at the moment with youth diversion orders. I know, Jonathan, you've been supportive of those and their introduction, which is on the way. Could you say a little bit more about them and why you think they're needed and why they're an important tool in this space?
Yeah, I remember going to meet the investigator in one of the many child cases, young autistic child arrested because they had detected material on their computer which was in contravention of tact. So there's an offence of having information useful to a terrorist. And I remember speaking to the officer, and they said, "Well, look, we're fed up with coming across these young people, and we don't really have any sort of playbook or options. We only have the option because we are worried about them. That's why we've carried out an arrest." And I have to say, I'm pretty satisfied, having quizzed the officers involved, that they carry out what they call executive action, so arrests or search, when they feel that there is a degree of risk that can't be managed just by monitoring it. But they feel that once they've gone through the door and they've discovered this material, that there's really no alternative but to arrest, prosecute, put on bail, bring back, charge, etc. And I was affected by the Rhiannon Rudd case. I have to say, she was on bail for a very long time. While she was on bail, any prevent support, so the benign aspects of prevent, which shouldn't be ignored, in other words, having a counsellor, someone who might be able to talk to them, not just like their parents. I mean, remember, Rhiannon Rudd's father, stepdad or wife's boyfriend was a neo-Nazi. So having an independent person who can support them is really important. None of that could happen whilst they were going through the criminal justice system, because if I was a defence advocate or solicitor, I'd say don't speak to them because you might implicate yourself. So I was really struck by that. And so I propose that now this is coming forward in legislation, an alternative measure, which I should say has got some red flags for civil liberties. And I'm going to be interested to hear what people think about that. It is not a criminal prosecution. So a court will be able to put an order called a youth diversion order on a child, which could ban them from using a device, or if they use a device, it'd have to have monitoring software on it, because so much of this is about children's use of phones, and it wouldn't require a conviction. It would be done at the civil standards. I mean, I understand very much that's a red flag when you think about the gold standard of criminal convictions, but it seemed to me, in a really difficult world where more and more children are coming across the terrorism radar, a better thing that they should not be convicted under the terrorism acts, but they should be diverted, required to, say, hand over their phones for monitoring software, attend some sort of session with a mentor. So that's the genesis. It was actually my conversation with that counter-terrorism officer who said, "Jonathan, I just don't know what we can do with this. I've had a go at suggesting it. It's now in the Crime and Policing Bill. I assume that it will go through Parliament. It seems to be quite a good idea. But I don't shy away from the fact that there are some aspects of it which can only really be justified by paternalism. In other words, the benign paternalism that we have towards children, which would probably excuse a degree of interference in their lives that we wouldn't countenance in the case of adults."
Thanks, Jonathan. Kate, from a advocate for young people in the criminal justice system, what do you think of that proposal, the new powers that are coming through in terms of those youth diversion orders? Do you think they're a helpful tool, or do you think they're infringing on children's civil liberties?
Well, it's a very challenging situation, because we have got a situation. These are children who, one of the options for the authorities, the counter-terrorism officers, is to consider charging that child and then going through a court process. And as has been identified, that process delays any support that child is receiving. And at the moment, the prevailing approach for children in the criminal justice system is to take a child first approach, and that's thinking about children first and building on their strengths and their abilities as a way of looking at the child first rather than their behaviour in terms of how you're going to prevent that in the future. So some of the aspects of these youth diversion orders really chime with that prevailing narrative that we're going to support children, we're going to avoid their criminalisation, we're going to try to remove formal processes. So ideally, this process would happen without any court intervention, and I appreciate there's a tension here, and I think Jonathan's really wrestled with it, and he feels the only way that these orders can be put in place is by having some sort of court adjudicated process. But the idea is that they're not getting a criminal sanction, and they're getting early intervention. If that works, and I think I'm going to steal your line, which is the devil is in the detail. If that works and it keeps them out of the formal criminal justice system, it gets them early access to support, then that would really enable, it would speak to all the evidence we know about preventing children committing offences or committing further offences, which is to build on their strengths, to enable them to get support, to think about wider aspects of their lives. I know Jonathan's concerned that a lot of these offences are committed because children are spending huge amounts of time on the internet, on devices, without any level of supervision. Well, actually, if what we really want is therefore to divert children away from this, we need to give them activities, productive activities. They need to be going to youth clubs. They need to be supported by experienced youth workers. They need to be allowed to pursue other activities that get them out of their bedrooms, that get them socializing, that get them developing peer relationships, which may prevent their social isolation. But that doesn't come from that being sort of imposed upon them. It begins working in partnership with them, listening to them, working out where their interests lie, and then taking a sort of non-criminal approach. So I think that there are aspects of the youth diversion order, and to speak to your earlier point, if it can be approached without an admission, because we know that children don't always come forward with an account right at the beginning of proceedings. If that was to be a barrier to this, then I think that would really be a missed opportunity, because actually what we really want is we want to get in earlier with these children, divert them away from being involved in much more serious offending. Yes, there are concerns. Yes, there are red flags, but I can see that if they were implemented well, then actually it speaks to all of the aspects of putting children's rights at the heart of our approach to children in contact with the justice system.
And one of the really important elements for these sorts of mechanisms to work well is a child having effective and timely legal representation at the earliest possible stage, in particular when they're brought into custody for the first time. And we know there's all sorts of different challenges for that, not least the strains and stresses that there are on the criminal defence space at the moment, with just simply not enough criminal defence lawyers available, and certainly an almost complete lack of specialist youth lawyers to support them, which is one of the things that the report finds. Miranda, like, one of the things you do is you look particularly at children in custody. Why is effective legal representation really important at an early stage for children when they're brought into custody, especially on serious matters such as terrorism?
For all the reasons you've just mentioned, in effect. So children are subject to a different legal framework, and that needs considering at the very earliest opportunity, as Kate was identifying. These orders are to be available. The question will be what is going to be said in interview, and a child needs advice from someone who understands entirely that process. But there are also, again, to Kate's point about the difference of children in contact with justice processes, that they need specialists who are able to engage with their different needs and capacities, and really importantly are able to communicate effectively with them, because the trust that is required in order to make those sorts of acceptances that these youth diversion orders, for example, are going to require, that needs to be established with that child in the really challenging setting of custody. So Kate and I have been lucky enough to work on a trial recently looking at child specialist legal advice in police custody. It's been challenging for a number of reasons, but what we see is that if you bring a child specialist into that space, they stand out in comparison to other non-child specialist lawyers in terms of going the extra mile for children, and in particular in making contact and making meaningful contact with children. And when children talk to us about what those experiences look like, it's that communication that's really key. Being able to talk to a child in a way that they understand is essential. So the kind of general movement is towards specialisation. You'll know that the UN General Comment focuses on the importance of specialist training, and we're really hopeful in this legal space that child specialisation is coming, and it can't come soon enough in our view.
Yeah, if I can just jump in there, Alistair. Yeah, it is coming. There will be an opportunity for legal representatives at the police station, solicitors, barristers, all through the justice system to be able to undertake specialist training and be recognised as child specialists. That is coming. The real challenge at the police station would be to have a child specialist rota. And I think it is about thinking completely differently and looking at children completely different, not modifying an adult system, starting with a completely different approach. So do you actually even need to arrest the child? They could come in under what is called a voluntary police interview, a caution +3. That is a mechanism that avoids them even being arrested. It means that they're much calmer when they come into this suite. It means that it enables their lawyer to be present at a time that means that, you know, it meets with their diary commitments. It means they can be supported by either a parent or a carer or an appropriate adult that maybe they already have a relationship with. So just starting right at the beginning with avoiding the normal processes that a criminal justice process routinely involves, but for children doesn't need to. It just doesn't need to. You take the arrest out, you have an interview, but under caution, and then having different avenues, including youth diversion orders, but there should be much earlier opportunities to divert children before getting to a youth diversion order. And I can see Jonathan wants to speak, but it needs lawyers who understand that those avenues are available and are having conversations with the officers about exploring that right at the early stage. Sorry, Jonathan.
I was just going to raise a slightly naughty point, which is about the knocking of prevent. I mean, I think, like Alistair, I mean, I've been looking at the evidence in the Rudy Cabana case, and it's not the only example of its kind. There was that 15-year-old girl who stabbed, I think, murdered a teacher, attempted to murder a teacher in Wales. And there was you often have parents who are really, really terrified of their children, acutely aware. In Rudy Cabana's case, experiencing violence at this young man's hands, aware that he was stockpiling weapons. Rudy Cabana's father was worried about speaking to the authorities, and worried in the same way as we all would be as parents about speaking to authorities and sort of selling out our kids and doing something to their disadvantage. But actually, if you think about the Rudy Cabana case, I know it wasn't terrorism, but it's pretty close. I mean, it would have been a good thing if he had gone to the police and said, you know, it's not just a case of me being worried. There is a real emergency here. And I wondered if there is a point here, this sort of knocking of prevent, which I think on the whole is worth having. Is that actually a good idea that prevent is being knocked and that people should be told, be careful about prevent? Because probably, if you think about the Rudy Cabana case, if prevent was, as Lord Anderson said, a big front door, big front door is the idea he's got. So any sort of concern, whether terrorism or violence fixation, you should be able to go to the authorities. I suppose in theory, if Rudy Cabana's father or mother, I think the father was more engaged, had gone to the police and said, I've got this really dangerous, worrying child stockpiling weapons, looking at endless fixation about, massacres. If he'd done that, could that have actually led to some intervention? And conversely, does saying, well, the authorities, you've got to distrust them, prevent is a bad thing, could that put people off? And I suppose I'm really saying that to dovetail with Kate's point. Kate may not agree with this, but I think Kate is right that you need to have a different way of looking at this, which is more of a child-centered problem solving rather than simply trying to resolve this through the criminal justice system. And I mean, Kate, look, you're not going to get lawyers advising whether they should have an arrest, but it would be ideal, and I've had this conversation with counter-terrorism police, if rather than going through the door with, the warrant, potentially even an enforcer to knock the door down, the drama of the arrest, it'd be nice actually if police could speak to parents.
I think there's a few things just for us to dig into there. On that side, Kate, do you want to come in first?
I mean, I guess what the word that hasn't been spoken about yet is safeguarding, and thinking about these children, and where you go to when a child has challenging behaviour. And I think one of the risks is austerity has underfunded the support available to families, and police aren't trained to support families with challenging behaviour. So calling the police in these situations is likely to escalate. We hear it all the time about parents with children who maybe have been violent in the family home, the police get called and it escalates a situation, when really what we need is skilled professionals used to working with children to come in and support that child and that family. So perhaps we need to, look at the proposal that CRIN have put in their report and say, what is it that we actually need to deal with this very specific issue, which predominantly is children, not always, obviously, but predominantly children committing offences online, or it's starting online, or at least it's being exposed online through the counter-terrorism approaches that are revealing it. But having a child-centred, child rights approach that doesn't feel scary to parents, that feels supportive, that actually is supportive and gives them the support they need to divert that child at that early stage. Having an organisation and an approach which is sat in the Home Office, when really it should be in education and health. That's where it should be. I can see your face, Jonathan, but in reality that's where it should be. We should be thinking about this as a safeguarding and a health and well-being issue in the first instance, and if you got in really early on, before the issues have escalated, then maybe terrorism wouldn't even have occurred, because you've got in really early and given a child and their families the support they need.
Thanks for that, Kate. I'm going to just keep us moving on, but we can perhaps return round to that bit again, because I think there's more to be discussed in that. I want to just pick up on some of the other themes in the report, particularly around trial of children accused of terrorism. And one of the things we pick out is that there's this tension between the use of youth court versus Crown Court and the different environments children may be tried in. Mark, I was wondering, from your experience, if you could say a little bit around why it's so important that we consider carefully the location, the format in which a child has their case looked at.
Yeah, Crown Courts are extremely intimidating environments for children, and they are by design intended to promote and protect the majesty of the law, but also their very structure it is works to promote the orderly administration of justice, and none of that is helpful for children appearing in Crown Court. Now, considerable work's been done over the years to adapt procedures layout and the use of language in order to make it more easy for child defendants to follow proceedings. And considerable strides have been made, particularly to be seen in the Child Defendants in the Crown Court Bench Book, the most recent edition of which is June 2025, which is has a forward by and is led by Mrs. Justice May, who's the Youth Justice Lead. And so an awful lot of work has been done on that to remind judges that child defendants shouldn't be treated as mini adults, but and that the courts should have regard to the fundamental principles of the criminal justice system, so to prevent offending and to promote the welfare of children. And so that there are a number of measures that are mandatory for, at least to be considered for children going on trial for serious offences. And those include that the judge has to have a ground rules hearing to consider what adaptations can be made to the physical layout, to the procedure, and to the language, that the ability for live links, for intermediaries to be present in order to assist the children. But the reality is that sometimes the judges are slow to adopt these procedures, reluctant to do so. Sometimes the very momentum of a trial makes it difficult for the court to take the time that it needs in order to ensure that the child is following the proceedings. And there are physical limits to the very geography of a courtroom. The judge will be raised up. There'll be jury members, which is not something that you'd find obviously in a youth court. There'll be other members of the public who most likely would be permitted to observe. Docks are frequently enclosed, and often, whilst there's provision for children to sit outside the dock behind their lawyers, often there are practical problems with making that happen. Perhaps there are adult co-defendants, perhaps there are a number of child defendants, and it's just not possible for the practical for court security to deal with those sort of adaptations. And so very many child terror defendants will end up in the Crown Court because of the structure of the legislation. But there is a grave concern that although most Crown Court judges do their best to adapt the procedure to in the way they ought to in order to guarantee the participation of the child, nevertheless, the experience is very likely to be entirely overwhelming for them, and there's little that can be done within the structure, within the buildings, and within the structure of proceedings in the Crown Court to make sufficient adaptations in order to make the trials fairer for children. So there is a problem with that, and the question is whether the terror jurisdiction ought to be of the youth court ought to be inflated substantially in order to deal with more child defendants. That's a question for further debate.
Kate, do you want to reflect on that as well?
Well, it's a very interesting tension, and James spoke at the beginning about quite a lot of the themes of the report do speak to sort of the wider issues within the justice system for children and tensions that are identified across the justice system. And one of them is this tension between the youth court and the Crown Court. So the youth court is described as a specialist court, and is supposed to be a court that is designed to meet children's needs. I think the challenge, because I've been in many of these debates, is most advocates who represent defendants in the youth court and the Crown Court if they had their own child facing criminal proceedings, would say they think that they will get a fairer process in the Crown Court. There are many challenges to having a fair trial in the youth court when you have complex cases. The same judge determines legal issues as makes findings of fact. And so I think that really the point that James has already talked about is that really what we really need is we need to enhance the youth court. And for serious cases, it's absolutely right that children should be in a specialist court, not in an adult Crown Court. And it's absolutely right that everybody should move to them. So we should have circuit judges coming to a space that is designed for children. We should, if needed, have juries, perhaps, I don't know, this is controversial, smaller juries, but coming to a space where children are being tried. That must be right. But I think the youth court, as it currently is, would not be able to deal with the complexities of the evidence and the way in which they're structured, and the fact that they are aligned to the adult magistrates courts means that often cases aren't prepared in the same way as they're prepared in the Crown Court. So you do really need to have an enhancement of the youth court to enable it to provide a fair trial for these children, but it does need to be away from the glare of the adult proceedings, hopefully less keep their anonymity, as is automatic in the youth court, has to be requested in the Crown Court, limit access to the public gallery, allow them to have their best chance of participating in proceedings, because as the Equal Treatment Bench book talks about, communication is the cornerstone of access to justice. If you can't follow your trial, you have not received a fair trial. So we definitely do need significant change in this area, but it doesn't come by bringing children back to the youth court. I think there are real risks associated with that. We need to enhance the youth court in order to do that. But I give way to Jonathan, who's got his hand up. Sorry.
Jonathan, go ahead.
No, don't give way at all. I mean, I was just really thinking I would build upon what you're saying, Kate, actually, which is I would demote the concern about procedural fairness and increase the concern about substantive fairness. In other words, I understand that you need to have child advocates, specialists who understand you can make sure the child's participating. But actually, when it comes to terrorism legislation, the offences under the Terrorism Acts are really about stuff that before you've really committed any harm. So, for example, having a terrorist manual. Now, with an adult, it's possible to say that that is culpable, just about. And it's also possible to say, well, they had it because they represented a risk of carrying out a terrorist attack at some stage in the future. I think with a child, it's really quite hard. I think it's quite hard to talk about culpability in the context of mere possession of documents. And I think it's also quite hard to talk about enduring risk in the context of children, because frankly, none of us really know how children are going to end up. So, I mean, I wanted just to push the point a bit further. What you really need is not so much a court with even greater procedural protections to ensure that they can participate as good as an adult, but actually a new way of doing business, which is to try. I mean, I'm almost thinking about MAPA, which is a multi-agency panel that deals with risk on release, but actually could also be used to deal with risk when children have been arrested. In other words, a lot of people in a room trying to work out what's the best solution, of which prosecution to conviction is one example, but I don't think the only solution.
Miranda, do you want to come in there?
I just wanted to endorse that, the point that you're both making effectively about the kind of challenge of the adversarial process. We need a problem-solving approach for children, and we need to start again to think about, as kind of previous reports, Charlie Taylor's report on the youth justice process, you know, we've talked about this again and again, but it will take some political will to advance it. But we need something that looks more like potentially the Scottish hearings, the children's hearing system, where the whole of the context of the child's experience, behaviour, home life is looked at without kind of punitive consequences hanging over the head of that child, in proper appreciation of the difference that children present for the justice process.
We're kind of beginning to run out of time together this evening. I'm just going to give everyone, all the participants, a chance to share maybe a final reflection before maybe Mark wraps up for us. James, do you want to go first for us?
Yeah, I'm interested to hear that there's a sort of a general consensus that we have a major problem and we need a major rethink of how we do youth justice. I think generally it seems to be the consensus, but also in particular in this space. And I would again push that whatever way we do it, whether it's substantive justice, whether it's procedural justice, the child rights and our international obligations are held held front and center when we're thinking that through.
Thanks, James. Miranda, would you like to share any final reflections?
Just to throw a spanner into the works, of course, all these discussions raise the question again of our very, very low minimum age of criminal responsibility. So I appreciate there's no political will, but I think it's important to raise this in this context.
Jonathan.
I mean, on the low threshold, on the low criminal age of responsibility, I would say be very careful what you wish for. See Foxtrot Network in Sweden is what I would, if anyone Googles that, they'll see some pretty astonishing outcomes where children cannot be prosecuted under the age of 15. I would just leave it with this thought, which is all of this stuff comes to the internet. All of it, all of this terrorism offending comes to the internet. We haven't talked about it, but the only real answer is to stop, as in Australia, stop children using social media. And Ofcom, I'm afraid, has got too big a task on its hands to deal with the avalanche. And the tech companies have got one customer only, which is the advertisers. And they have, I think there's a very good phrase, they've socialized the problem and privatized the profit. And I genuinely think that until we go back and back and back to the internet, we are never going to solve the source of the problem.
Thanks, Jonathan. Kate.
Well, I'm just going to use your own words in the start of your report, which is children's rights can be protected without compromising security. I think, in fact, they have to be protected in order for us to protect security, because actually once you start with children's rights, once you focus on the child and start exploring their needs, then you're actually going to find a much better long-term solution to preventing them committing offensive violence, which is what we're really concerned about. And if that's what we want, we need to really have a children's rights focus, and we have to recognise that regularly the commonplace situation is that they are being groomed into this behaviour by others. And we've got to understand that, look at the child from a child rights perspective in order to think about public safety.
Thanks for that, Kate. I'll hand back to Mark now, just to say, I think Jonathan's spot on. The elephant in the room here is the internet space, the online space. It's one we haven't gone into tonight. Maybe it's one we could come back to again in the future to discuss further. I suspect there's a lot of teenagers, if they overheard you then, Jonathan, throwing their phones out the window. Well, maybe not throwing the phones out the window, but there's a revolution happening right now as a result. But I'll hand over to Mark to wrap up for us tonight.
Can I just deal with one question that's come up for, I think, principally for Kate, following on from Kate's comments about the critical need for specialist children defence representative at police station. How would this work within the present overstretched criminal defence solicitor system? And the suggestion is that individual child specialist duty solicitor or duty district from general duty solicitor seems sensible approach. What do you have any ideas, Kate, about how in practice this might work?
Yes, I mean, you're absolutely right. What we expect of criminal duty solicitors is a huge amount for incredibly poor remuneration. I recognise that. So that the practical approach would be to have an adjunct or an add-on to the criminal defence call centre rota, and it would be a child specialist rota. But what would have to come hand in hand with that is adequate funding. And if Jonathan's right that the TACT officers, they want to be able to engage with lawyers, they want to have an earlier conversation, we've got to pay lawyers. As it currently stands, they're paid about £300 for the entire legal representation for children until it gets to court. It's just not a practical approach to expect lawyers to be able to put in the amount of time that would be required in order to divert children properly at the police station. As you pay them properly, you've got to do that. So I recognise that. Thank you very much for raising that point. And, you know, it's a really challenging job. I know that we may move to a time where these are interviews by appointment, but at the moment it's, you know, getting a telephone call at 2 in the morning and being expected to go down to a police station in order to represent the interests of detained persons, whether they're children or adults, for a very, very poor pay. And we need to change that. We need to invest in our specialist legal advice if that's the direction of travel. So thank you.
Well, thank you to the panel, and I hope that those listening have found that useful. And for my part, it's refreshing to see so much creative thinking and determination to address the problems that the terror legislation, that the internet and the collision of children with the youth justice system are causing. And perhaps I could finish with a paragraph from the end of the report, which says this: as a nation, we have a choice. Do we continue to treat children with suspicion, pushing them further into the auspices of the criminal justice system, or do we offer them safeguarding, support, and rehabilitation? The UK's current trajectory leads towards the former, but it's not too late to change directions. Rather than punishing children, we can choose to protect them. And I'll leave you with that thought. Thank you very much for joining.